If you're married to a U.S. citizen or planning to bring your spouse to America, what I'm about to tell you in the next few minutes could completely change how you approach your green card application. The rules have shifted as we enter January 2026, and thousands of couples are already feeling the impact. Some applications that would have sailed through last year are now facing unexpected delays and requests for mountains of additional documentation. Whether you're just starting this journey or you're already months into the process, stick with me because I'm going to break down exactly what's changed, what you need to prepare, and how to avoid the costly mistakes that are tripping up families right now. Welcome back to the channel, and if you're new here, this is where we cut through the confusion and give you straight talk about U.S. immigration. I'm here to help you understand the complex world of visas and green cards in plain English, so you can make informed decisions about your future. Today, we're diving deep into marriage-based green cards and the significant changes that took effect this January. Make sure you subscribe and hit that notification bell because immigration policies keep evolving, and you'll want to stay updated on changes that could affect your case. Let me start by saying this. The foundation of marriage-based immigration hasn't changed. If you're a U.S. citizen, you still have the right to petition for your foreign spouse to receive a green card. The basic process remains the same, filing Form I-130, going through either adjustment of status or consular processing, and eventually obtaining permanent residence. But the devil is in the details, and those details have become significantly more demanding in 2026. The most substantial change revolves around evidence requirements, and this is where I'm seeing the biggest impact on real families. USCIS has dramatically increased the documentation threshold for proving that your marriage is genuine. They've always required proof that marriages are real and not just for immigration benefits, but now they want to see a much deeper paper trail. Your marriage certificate alone isn't nearly enough anymore. You need to paint a complete picture of your life together through documentation. This means joint bank accounts with at least 6 months of statements showing both names and regular activity from both spouses. They want to see joint leases or mortgages, utility bills in both names, car insurance or health insurance policies, listing each other, tax returns filed jointly if you've been married through a tax year, and photographs spanning your entire relationship with clear dates and locations noted. Here's what makes this challenging. Many couples, especially those who just got married or are in long-distance relationships while waiting for visa processing, don't have extensive joint financial entanglements yet. If that's your situation, you need to be strategic. Start building that documentation immediately. Open a joint checking account and use it regularly. Add your spouse to your lease if possible. Get joint car insurance. Keep every receipt from trips you take together. Save airline tickets, hotel reservations, restaurant bills. If you're communicating across borders, keep logs of your phone calls, video chats, and messages. Save cards and letters you exchange. Get written statements from friends and family who know your relationship well, and make sure these statements are detailed, not just generic letters saying you seem happy together. The interview process has also intensified considerably. Almost every marriage-based green card application now requires an in-person interview with both spouses present. These aren't casual conversations anymore. Officers are extensively trained to detect marriage fraud, and they're asking increasingly detailed questions designed to reveal inconsistencies. You might be asked what time your spouse wakes up each morning, what they eat for breakfast, which side of the bed they sleep on, details about your first date, how you celebrated your last anniversary, names and ages of each other's siblings, what's in your bedroom or bathroom, who does which, household chores, or what you argued about most recently. Now, before you panic about memorizing every detail of your lives, understand this. The goal isn't to have robotically identical answers. Real couples remember things differently and have different perspectives. What officers are looking for is consistency on major facts and genuine knowledge of each other's daily lives. If one spouse says you have a cat and the other says you have a dog, that's a problem. If one spouse says you met in 2023 and the other says 2024, that's concerning. But if you disagree about what color shirt someone wore on your third date, that's completely normal. Processing times have stretched significantly under these new protocols. As of January 2026, you should expect Form I-130 processing to take between 14 and 20 months, depending on which service center handles your case and the complexity of your situation. This is substantially longer than what we saw even 6 months ago. The increased scrutiny means officers are spending more time on each case, and USCIS is also working through accumulated backlogs. If you're planning your life around this timeline, build in extra buffer time. Don't book non-refundable travel or make major commitments based on best-case scenarios. Immigration rarely moves faster than expected, but it frequently moves slower. For those of you holding conditional green cards, the January 2026 changes affect you directly. Remember, if your marriage was less than 2 years old when your spouse received their green card, it's conditional and only valid for 2 years. Before it expires, you must jointly file Form I-751 to remove those conditions. The new requirements for this process have become more stringent. USCIS wants extensive proof that you've built a genuine life together during those 2 years. They're looking for evidence of significant shared experiences and commitments. This includes major purchases made together, perhaps a home or vehicle, children born to the marriage, shared financial investments or retirement accounts, evidence of joint participation in each other's families and lives, documentation of supporting each other through challenges, and continued financial intermingling beyond just a joint checking account. The timing of filing Form I-751 is critical. You must file within the 90-day window before your conditional green card expires. File too early and your petition gets rejected. File too late and you could fall out of status. Set multiple reminders for yourself because missing this deadline has serious consequences. Let's address the financial requirements because this trips up many couples. The sponsoring U.S. citizen or permanent resident must demonstrate they can support their spouse financially without the immigrant needing public benefits. This requires income of at least 125% of the federal poverty guidelines for your household size. For a 2-person household in 2026, that's approximately $26,000 annually. You'll need to provide 3 years of tax returns, recent pay stubs covering at least 6 months, a letter from your employer verifying your position and salary, and possibly bank statements or evidence of assets if income alone is borderline. If you don't meet the income requirement, you can use a joint sponsor who does, but that person takes on significant legal responsibility and must also provide comprehensive financial documentation. Here's something important that many people miss. Even if you filed your petition before January 2026, USCIS can apply current standards to your pending case. They can issue requests for additional evidence based on the new requirements, even if your initial filing was under older guidelines. This means you can't assume you're grandfathered in just because you filed early. Stay prepared to provide updated and additional documentation at any point in your case. For couples where the foreign spouse is currently in the United States on another visa, timing and intent become crucial considerations. Getting married and adjusting status while in the U.S. is legal, but entering the country with the preconceived intent to do so when you have a non-immigrant visa can constitute fraud. Under the 2026 guidelines, USCIS is scrutinizing these cases more carefully. If you entered on a tourist visa and married within 60 days, expect detailed questioning about your intent when you entered the country. Be prepared to show that circumstances changed after arrival or that you genuinely didn't plan to marry and stay when you entered. If your spouse has children from a previous relationship, these derivative beneficiaries face unique challenges. Unmarried children under 21 can be included in the petition, but they must remain unmarried and under 21 throughout the entire process. With processing now taking 18 months or more, a child who's 19 when you file might age out before the petition is approved. The Child Status Protection Act provides some relief, but it's complicated and doesn't help in all situations. If stepchildren are involved, consult an immigration attorney early to understand your specific timeline constraints. For those going through consular processing abroad, the January 2026 changes have affected embassy and consulate procedures as well. After USCIS approves your I-130, the case moves to the National Visa Center and then to the appropriate embassy. These posts are now requesting substantially more documentation before scheduling interviews. Expect multiple rounds of document requests and be prepared for longer waits between approval and interview scheduling. Consular officers have received additional training in fraud detection and may request follow-up interviews or even conduct verification visits to confirm addresses and circumstances. Let me give you some practical strategies for success under these new rules. First, organization is everything. Create a comprehensive file system from day one of your relationship documentation. Use clear labels, dates, and categories. When you submit your application, don't just meet the requirements, exceed them. Provide a detailed cover letter explaining your relationship timeline, how you met, how you fell in love, and your plans together. Make the officer's job easy by presenting a clear, compelling narrative supported by strong documentation. Second, prepare intensively for your interview. Spend time together discussing your daily routines, your memories, your plans. This isn't about memorizing scripts. It's about being thoughtfully aware of your shared life. Review your petition and supporting documents before your interview so details are fresh. Bring additional evidence to your interview beyond what you've already submitted. Original documents are better than copies when possible. Third, consider professional help seriously. While many couples successfully navigate this process alone, the complexity of the 2026 requirements makes attorney guidance increasingly valuable. A qualified immigration lawyer can identify potential issues before they become problems, ensure your documentation is comprehensive and properly organized, prepare you for interviews, and respond effectively to requests for evidence. Yes, it costs money, but it can prevent much more expensive delays or denials. Stay proactive throughout your case. Track your status online regularly, using your receipt number. Know the normal processing times for your service center and follow up if yours exceeds them. Respond immediately to any USCIS requests, never missing deadlines. Keep USCIS informed if you move or change contact information. And stay educated about policy changes that might affect your case, because immigration law continues to evolve. The bottom line is this. Marriage-based green cards are still very much obtainable in 2026, but the process demands more documentation, more patience, and more preparation than before. These changes can feel overwhelming, especially when you just want to be together with the person you love. But remember that USCIS processes hundreds of thousands of these applications successfully every year. Your genuine marriage, backed by thorough documentation and careful preparation, can absolutely result in approval. The key is understanding what's required, starting early, being comprehensive, and staying persistent through the inevitable bureaucratic challenges. If this video helped clarify the new requirements for you, please give it a thumbs up and subscribe to stay current on immigration updates that could affect your journey. Leave a comment sharing where you are in your process or any questions you have. While I can't give personalized legal advice in comments, I do read them and try to address common concerns in future videos. Remember, for advice specific to your situation, always consult a qualified immigration attorney. Thank you for watching, and I'm rooting for your success. The path to your American dream with your spouse might be longer and more complicated than you hoped, but it's a path thousands walk successfully, and with the right preparation, you can too. I'll see you in the next video, and until then, stay informed, stay prepared, and keep moving forward.